technically, VLSI is a non-practicing entity. They don't make computer chips, but they are actually acting on behalf of a Philips Corporation subsidiary called NXP Semiconductor, which is one of Intel's biggest competitors. And so rather than sue themselves, NXP hired VLSI and Morgan Chu, this famous attorney, to bring the patent case for them. So it's really, as I perceive it, a fight between two big competitors. In a court case, we really don't care what the characteristics of the parties are, whether they're big or small, or an inventing company or a producing company. What we're concerned about is the patents themselves and the law governing infringement. But that being said, when you have a $2 billion verdict, of course, that will cause other companies, other competitors to think that perhaps they could get an advantage by suing on some of their semiconductor patents. And so this could be a stimulus to a little more litigation.
If I was VLSI, I wouldn't spend the money yet. The number of doctrinal equivalent cases, Judge Rader, in the last 5 years, we can count them probably on two hands. And so that will be an issue, I'm sure, that will be litigated on appeal. And that's why I think there has not been as much litigation in the microprocessor area, and because there's cross licenses between lots of companies.
It probably also reflects just differences in the technology too. When the dean talked about the minimizing the consumption of power and emphasizing the efficiency of the speed, those are pretty important processor technology. It could be that the technology in the Chinese case was not as important. But I would like to comment, one of the ways that Chinese judiciary can strengthen their protection of intellectual property is by awarding damages that are compensatory. They really compensate for the full value of the technology. Now, this $2 billion award suggests that this technology is worth an enormous amount. Every processor relies on speed and energy consumption. And I think that one lesson that China can take from this is that as they increase their intellectual property protection, they'll need a stronger damages system to compensate for past infringement. The Chinese system relies on injunctions usually. Well, that halts infringement going forward, but that gives an incentive for companies to delay paying any licensing fees, royalties, until the court forces them to, and they can go for years perhaps without paying fees. The Chinese system needs a stronger damages award to compensate for past infringement. That will, I think, properly reflect the value of the technology. One point that's really important is that in the US system, the choice of court and the choice of judge is very important. This case was litigated before Judge Albright, a new judge who is very protective of intellectual property. He sent it to a jury in Texas, which is, again, very historically protective of intellectual property. You need to be very aware that different courts have different procedures in the United States, and those can affect the outcome very remarkably.
You can't think of this as foreign litigation or home litigation. I mean, if you're a worldwide company and you're making things around the world, it's inevitable this is going to happen. Companies have to approach this not as this is the US ganging up on a foreign company. They have to approach it as we are a worldwide company and we need to understand the various pros and cons of doing things in different countries and have partners in each of these countries and even offices. The same is true of US companies doing business in China, which is happening more and more. They need to develop partners. They need to have law firms they can rely on. They need to hire people that they can then place in those countries who understand the culture, who understand the laws. And I think it's not just the laws. I think it's the culture, it's the system. There's a lot of things gained, I think, by hiring people who have experience from living in both countries or being educated in both countries.
The way to avoid all this litigation, of course, is licensing, where the companies share their technology amongst themselves and negotiate in advance how much they're going to pay for each other's technology. That has traditionally happened in the semiconductor area, but this time the companies perhaps couldn't agree on a license rate, and so we ended up with litigation.